As most people know, when the petitioner dies, the petition dies with him. And I know how crushing that can be for people. Some people have waited decades for the priority date on their petition to become current. They're looking forward to either coming to the U.S. or, if they are in the U.S., to finally get the green card, a new and better life for themselves and their family members. However, there could be hope. Even if the petitioner died, it is possible for the petition to live on, either through humanitarian revalidation or Section 204L, which I call the survivor law. And we're going to be talking about what is involved in asking USCIS that even though the petitioner died, could they allow the petition to live on? And if you enjoy this channel, of course, make sure to like and subscribe. When the petitioner dies, there could still be hope in that a person could apply for either humanitarian revalidation or Section 204L, which I will call the survivor law for these purposes. Let's talk about the differences between humanitarian revalidation and the survivor law to determine if perhaps you are eligible if the petitioner died. Okay, humanitarian revalidation. That is available if the beneficiary had been outside the U.S. when the petitioner died and the petition has already been approved. If the beneficiary arrived in the U.S. after the petitioner died and continued living here, and then the priority date becomes current, they would still have to seek humanitarian revalidation because they were not here on the day the petitioner died. Also, you need to make a compelling presentation to USCIS as to why they should allow the petition to live on despite the death of the petitioner. And they look at a number of factors, and those factors include the impact on your family who are living in the U.S., especially if they are citizens or green card holders, whether the alien is elderly or sickly, the alien had lawful residence in the U.S., their lack of ties to their home country, as well as other factors a person believes is important for USCIS to take into account as to whether or not they should exercise discretion and approve the case. It has to be well packaged, well presented, and have lots of documentary proof. A lot of people think that they can do it themselves and it's easy, but it could be very, very difficult. In fact, I pointed out that the California Service Center had at one time a 7% approval rate. So you have to make sure it is well done, well prepared. As far as Section 204L or the survivor law, that is, in my opinion, so much better and easier than humanitarian revalidation. Now, the requirements are that the principal beneficiary or one of the derivatives had to have been in the U.S. when the petitioner died, and they have to have continued to live in the U.S. all that time. So in other words, you cannot come into the U.S. when the petitioner's on their deathbed, they die, and then you go back to your home country. That may not constitute that you were residing in the U.S. There are also several more advantages to the survivor law. First of all, the petition could either be pending or approved. For humanitarian revalidation, the petition had to have already been approved. For survivor law, it applies whether the petitioner or the principal beneficiary died. For humanitarian revalidation, if the principal beneficiary died, that's the end of the case. There's nothing more that can be done. But the survivor law, there could still be hope. In fact, I had a case once where a sister had petitioned her brother in F4, waited many, many years, and then the brother died. The one who was being petitioned died. Nevertheless, we were still able to get a green card for his wife, the derivative spouse, even though the principal beneficiary died. In addition, the survivor law could also apply if a worker died. The spouse could still possibly obtain a green card. Let's say, for example, somebody is being petitioned by an employer under labor certification or PERM, and the worker dies. It could still be possible that the spouse and the minor children could move forward on that case, the I-140, and get their green card. Also, both humanitarian revalidation and the survivor law require that there be an affidavit of support submitted by a substitute sponsor. And the substitute sponsor has to be a citizen or a green card holder and can only be certain relatives. And those relatives who are qualified to act as substitute sponsors include a spouse, a parent, in-laws such as mother-in-law, father-in-law, son-in-law, daughter-in-law, brother-in-law, and sister-in-law, as well as siblings, your brother or sister, a child, grandchild, grandparent, or a legal guardian. If a person has worked for at least 40 quarters or 10 years and they have a Social Security printout statement establishing that, then they may be exempt from the affidavit of support requirement. Aside from humanitarian revalidation or survivor law and whether you're eligible or not, there could be other issues in your case affecting your admissibility. For example, if you were out of status, you entered the U.S. under an assumed name or have other fraud, you have crimes or a prior deportation order, that could affect a person's ability to apply for either humanitarian revalidation or survivor law. So I would recommend that if you believe you are eligible, or you know of a friend, family member, a co-worker for whom this may apply or it could be helpful, then you should consult with an attorney who can evaluate your situation, determine eligibility, address the issues, help you package the case. Because once it's submitted, it takes at least a year to process. But it is so important, so critical, and sometimes you're only given one opportunity. And if it gets denied, it's very hard to go back and reapply. That's why I believe with something as important, as something as complex as your immigration future or the future of your family, you should consult with an attorney and have an attorney help you package your case. But this goes to prove that even though the petitioner died, or in some cases the principal beneficiary died, there could still be hope. Now, if you found this information informative, make sure that you subscribe to our channel and, of course, like and share. I'm Michael Gurfinkel, and this is U.S. Immigration TV.